Welcome to Lecture 13, which focuses on interest group participation in the Supreme Court litigation process. In the last several lectures, we've begun to dig into the stages of litigation before the court by examining first the agenda-setting process, noting that ideology isn't the only influence on decision-making, but instead we uncovered the tension and trade-off between legal considerations and the policy preferences of the justices. Then we turn to look at the next stage of the judicial process by examining merits briefs and oral arguments and looking at the impact of attorneys and the Solicitor General before the court. As we move forward, we're going to continue to unpack this particular stage, the merits stage, by scrutinizing other sources of influence on judicial behavior. So that's where we're picking up again today, by examining interest group involvement in the court. Interest groups are notably involved at both the agenda setting stage and at the merit stage once a case actually lands on the Supreme Court's calendar. Interest groups participate in almost all aspects of the American political system. We tend to be most familiar with interest group activity in electoral politics, where organized interest groups make campaign donations or actively campaign on behalf of a candidate. The presence of interest groups on Capitol Hill is unmistakable. Organized interest groups directly lobby legislators. They testify in congressional committee hearings and sometimes even draft legislation, all in an attempt to alter the direction of federal policy. Interest groups are similarly active in the executive branch, working with bureaucrats to implement legislation, monitoring implementation, and testifying before regulatory boards. Likewise, interest group participation permeates the judiciary. For nearly the last 30 years, interest groups have participated in 90% of the cases decided by the Supreme Court. Yet how interest groups participate in judicial politics is markedly different. So we'll begin by examining the strategies or tactics available to interest groups. We also want to know why and when different interest groups get involved in the process. What motivates different organized groups to become involved in the process? At what point do they enter the scene? Like interest groups in the other branches of government, the interest groups that participate in Supreme Court cases are not a homogeneous bunch. So who are they? What types of groups participate most often? And finally, we need to figure out, as always, if interest groups matter in judicial decision-making. So we'll conclude the lecture by assessing the impact of interest group activity on the decisions that the justices make. There are two primary ways for interest groups to participate in Supreme Court cases. The first is through sponsorship of litigation. At the most basic level, this means that at some point in the litigation stream, a group jumps in and starts writing checks for the litigation process. There are two different tactics a group might pursue if it sponsors litigation. First, an organized interest group can initiate something called a test case. This type of strategy means that an interest group spearheads litigation from start to finish by either challenging a law in their own name if they can establish standing, or by orchestrating litigation on behalf of an individual or individuals who do have standing. To see this in action, consider a quick example. One of the most famous test case initiations occurred in Brown versus Board of Education in 1954, where the NAACP recruited litigants in Topeka, Kansas, and other cities across the country to challenge racial segregation in school. The NAACP didn't have standing in its own name, so they sought out people to be the face of the case. But the NAACP then organized the lawsuit and provided the financial resources to bring the case all the way to the Supreme Court. Sponsorship can start at a later stage in the litigation stream, too. Interest groups can take over a case that individuals have begun once it reaches the appellate level, for example. The type of involvement is the same. The interest group literally finances the litigation, providing resources like attorneys, staff, and so forth. It just starts a little bit later in the litigation process. Let's again consider another case where the NAACP was intimately involved, the 1924 case of Moore versus Dempsey. That case started when 12 black sharecroppers were convicted of murdering 5 white men during a riot in Arkansas. During their initial trial, a bunch of armed white men stood directly outside of the courtroom, threatening to lynch the defendants if they were not sentenced to death. The sharecroppers' attorney were a joke. They didn't have any witnesses to speak on behalf of their clients and didn't allow the accused to defend themselves. The jury in the case returned guilty verdicts within 10 minutes of deliberation, and the judge in the case sentenced all 12 Black defendants to death. The NAACP was alerted to this case, and upon investigation decided to sponsor the appeal all the way to the Supreme Court. Sponsorship of litigation has played a critical role in cases that have appeared before the Supreme Court. In a 1993 study, Professor Lee Epstein found that from 1986 to 1991, 17 of the 34, or exactly half, of the most important decisions of the Rehnquist Court were sponsored by interest groups. A second mechanism for participation is amicus curiae, which literally means friend of the court in Latin. The tradition of amicus participation dates back to Roman law, where the so-called friend of the court would provide an outside perspective, primarily geared to make sure that the court avoided an erroneous decision. This continued in the English system up through 1736. Then in 1736, in the case of Cox versus Phillips, where someone was trying to get out of a marriage, the English court allowed for the participation of amici to advocate, and amici, by the way, is plural for amicus curiae, so more than one, for an amici to advocate for a particular outcome. Today, amici are certainly not neutral friends of the court, but rather all advocate for a certain position, filing legal briefs in support of one of the parties in the case before the court. In the United States, the first adversarial brief was in the 1823 case of Green versus Biddle, which involved an interstate land dispute between Kentucky and Virginia. Ultimately, the representation for Kentucky didn't show up to argue the case, which resulted in an automatic loss. Henry Clay, who was a congressman from Kentucky, participated as amicus and argued for re-argument in the case. The court agreed to hear re-arguments, but still ruled against Clay's position. The first non-governmental appearance of amicus participation occurred in the 1904 case of Ahau versus the United States, in which the Chinese Charitable and Benevolent Association of New York filed a brief documenting mistreatment of Chinese immigrants in New York City. Interest group participation using amicus curiae briefs didn't really gain traction until the latter half of the 20th century, but now is by far the most common way for organized interests to participate in the judicial process. Since amicus participation is such a big part of the American judicial process, it's a good idea to know some of the details about how interest groups function as friends of the court. Amicus participation is governed by Rule 37 of the court's own internal rules. All amici, except the United States government, so that is the Office of the Solicitor General, have to request permission of the litigants to submit a brief in a given case. If one of the litigants denies permission, then the would-be amici has to ask the court to allow it to proceed. Since the early 1960s, the court has granted a very high percentage of requests when there is disagreements among the litigants. So almost all potential amici are able to participate. But there are also rules about the format of the briefs submitted by potential amici. For example, amicus briefs are limited to 30 pages per brief, though many briefs are longer due to various appendices. Amicis must submit 40 copies of the brief, and they must follow ridiculously strict formatting requirements, like the cover of the brief needs to be light green if it is filed in support of the petitioner, and dark green if it is filed on the side of the respondent. Amici can participate at both the agenda setting stage and the merit stage, though it's much more common for interest groups to file amicus briefs after the court has accepted a case when the case enters the merit stage. It should be pretty obvious that getting involved as amicus at the agenda setting stage is quite the gamble. It's really expensive and resource intensive to file a brief, and since the court rejects the vast majority of petitions appealed to it, interest groups are pretty reluctant to submit amicus briefs in support of or in opposition to a writ of certiorari. Participation is rare enough at the agenda setting stage that any involvement by outside interests stands out. For example, it's not uncommon for a mere 3% of all 9,000-ish petitions that sought review by the Supreme Court to have amicus involvement. Conversely, at the merits stage, there's oodles of interest group activity, and it's rarer for a case not to have interest group involvement than it is for a case to have interest group participation. There are two flavors of interest group participation at the merits stage. The first is the submission of a written brief. Essentially, this brief is written advocacy for a particular outcome in a case. Amicus brief participation is the main type of involvement that people talk about when they refer to the presence of interest groups at the Supreme Court. As this graph makes abundantly clear, participation in this type of case has increased dramatically and steadily since the 1950s, where in the early 1950s, only about 10% of cases had any amicus brief involvement. By the time we get to the early 2000s, we're at around 100%, which is where we've remained since about 2003. So what types of arguments do amici make in their briefs anyway? As amici, organizations provide information not contained in the briefs filed by the direct parties in the case. In other words, interest groups try to present an alternative legal frame of the case that advances their own policy goals. This slide contains amicus brief data from 12 non-randomly selected cases from 1951 to 1990. These data come from cases like Gideon versus Wainwright in 1963, a seminal right to an attorney case, and Robbins versus California, a 1981 search and seizure case. You'll notice that in the sample of amicus briefs presented here, all 52 contained new sources of information that were not captured in the briefs filed by the parties. Very importantly, many interest groups are specialists in particular areas of legal, economic, or social policy, and they bring social scientific information to the court to support their preferred outcome. Most amicus briefs in this sample presented new arguments for the case, while approximately 29% of the briefs reiterated arguments made by the direct parties involved in the litigation before the court. The vast majority of the briefs, almost 3/4, frame the brief in such a way to present novel legal arguments, while other briefs make policy or separation of powers style arguments. While amicus briefs are the most common way for interest groups to be involved during the merit stage at the court, there's a second mechanism for participation worth mentioning. In particular, organized interest groups are infrequently allowed to participate during oral argument. However, this is exceptionally rare because there is, again, this fixed amount of time that the court allocates to hear argument in a case, typically only a half an hour for both the petitioner and the respondent. Given its infrequency, we'll focus on interest group participation through the submission of amicus briefs, but you should know that sometimes interest groups are invited to take part in oral argument. To this point, we've established precisely how organized groups might involve themselves in the judicial process and what types of arguments they're likely to make. But what motivates groups to participate in the first place? The basic argument is that an interest group wants to influence legal policy in cases that are of interest to the organizational mission of the group. In short, the group has a stake in the outcome and wants to make the collective voice of their group heard. That said, interest groups have to pay to play. It's a high-stakes game to participate as amicus curiae. Most interest groups are not legally based groups and need to pay an attorney to submit a brief on their behalf. This is not a cheap undertaking. It runs about $30,000 to $40,000 for an agenda-setting brief, and the price tag only increases from there for merit stage amicus briefs. Additionally, not all types of interest groups are the same. There is a difference between membership-based and institutional groups. Membership-based groups include groups like the American Civil Liberties Union, the National Organization for Women, and so forth. Institutional groups, on the other hand, include labor unions and private companies, where membership for the organization is typically non-voluntary. Given the differences in membership, it's not surprising that the two types of groups choose to participate at different times. In a relatively recent study, political scientist Thomas Hansford found that membership-based groups are more likely to participate when there's media attention paid to a case and where there's a pretty good chance that the side the group favors will win. This makes sense, right? Since membership-based groups depend on voluntary membership, they don't have a guaranteed revenue stream. The members of these interest groups then respond more favorably when their group spends money wisely and when the case is salient enough for the rest of the world to pay attention. Basically, participating as amicus in salient cases where your side is already favored to win is good publicity for a membership-based interest group. Plus, if the group didn't get involved in a landmark case, its membership might think the group isn't working hard on their behalf. Institutional groups, where membership is non-voluntary, have different motivations to participate as amicus. These groups include things like unions and state governments, where the members are members of the group simply because of employment or residency or some other non-voluntary characteristic. This means that the interest group has a guaranteed revenue stream that isn't likely to change in the same way that membership-based groups face. Like membership-based groups, institutional groups are more likely to get involved when there's more media coverage, but this matters much less to institutional groups. Instead, it seems like media coverage is merely a signal of the importance of the issue, but probably not a big driver for this type of interest group to get involved. And quite interestingly, institutional groups are completely unaffected by the likelihood that their side wins a case. Basically, institutional groups get involved in cases where the outcome affects their interests, whether or not they win or lose. And that simply is not true for membership-based groups. Interest groups of both types are more likely to participate when the Solicitor General of the United States has been invited to file an amicus brief, and when the attorneys in a case are relatively inexperienced. Building on what we've already learned this semester, this finding should make sense. We know that the Solicitor General is a particularly influential litigator, so when the OSG is involved, it follows that other interest groups want to stack up their influence against the OSG or want to align with it to tilt the odds in their favor. On the other hand, when attorneys are less experienced, interest groups seem to notice this deficit and find it in their best interest to help the inexperienced attorney by supplying more legal arguments for that party. While we can broadly classify interests as either membership-based or institutional groups, there are certainly many categories of participants within these classifications, ranging from individuals, like academics or congresspeople, to all levels of government, like the Solicitor General at the federal level or the state of Florida, for example, to public advocacy groups like the ACLU, to trade associations and unions. As this chart shows, the different types of interest groups participate at different rates. The data presented here contain the classification of almost 4,500 amici across more than 1,000 briefs submitted in about 250 cases from several different terms before the Supreme Court. The punchline is that state governments and trade associations appear the most frequently in terms of raw numbers. Some of these numbers are slightly misleading, however. Of the 253 cases, the United States federal government showed up in 92, or about 36% of them, typically through the participation of the Office of the Solicitor General. State governments appear in about 42% of cases. Early political science research suggested that there wasn't very much evidence for impact of amici on outcomes. This isn't so much true anymore. A 2008 study by Professor Paul Collins examines 57,000 justice votes from 1946 to 2001 and finds that amici influence the likelihood that justices will vote in a particular way. Specifically, holding all else equal, one amicus brief that advocates a liberal outcome will increase the probability of a liberal vote by roughly 3%. Each conservative brief, holding all else constant, reduces the likelihood by approximately 2%. Moreover, generally speaking, these results hold across all justices. While this seems like a really small net effect, it's a big deal when you consider the additive impact of amicus briefs. I'm going to talk through the results of this table, and you should make sure that you understand what it means, but I've also included the results in words on the next slide, so if you miss taking a few notes here, it's okay. All right, so this research shows that with 3 briefs filed for both the conservative and the liberal side, the baseline probability that a conservative justice casts a liberal vote is 44%. The probability that a liberal justice votes liberally is 77%. This is what we should expect, where liberals are more likely than conservatives to cast votes in a liberal direction. If we hold the number of liberal amicus briefs at 3 and increase the amicus briefs supporting the conservative position to 9, we see a sizable decrease in the probability that a justice casts a liberal vote. Specifically, the likelihood that a conservative justice votes liberally drops from 44% to 27%. In other words, if there's more support for the conservative side of a case through amicus participation, conservative justices are even more likely to vote conservatively than they otherwise would be. When there are more amicus briefs supporting the conservative position, even the liberal justices are a little bit less likely to cast a liberal vote. We observe that the likelihood that a liberal justice casts a liberal vote decreases from 77 to 70%. But it gets more interesting if we consider a case with 9 liberal and 3 conservative briefs in this bottom row here, where the probabilities shift in the opposite direction and increase the likelihood of a liberal vote across the board. In fact, the probability that a conservative justice casts a liberal vote is slightly over 50%, 51%, and liberal justices become even more likely to vote with the liberal position. In short, when the deck is stacked against the conservative position, the voting behavior of ideologically conservative justices becomes more unpredictable. And we'll see conservative justices sometimes jump the ideological fence and vote with their more liberal colleagues. Recall that as the earlier slide demonstrates, most amicus briefs make at least some arguments that are otherwise novel to the court. That doesn't mean they are good arguments, just that they are providing the Supreme Court with options it might not otherwise have considered. The systematic implication of this is that it decreases the consistency with which justices vote conservatively or liberally. This slide simply contains the summary of the table results on the previous page, so I won't reiterate these points, but before moving on, it might be useful for you to pause the lecture to make sure that you've got a really clear picture of how amicus briefs tilt the scales in favor of a particular party by decreasing the consistency of justice votes. In addition to the relatively coarse measures of the effect of amicus briefs, the qualitative evidence gives a more nuanced picture of how interest groups have affected the development of law and legal policy. Anecdotally, there are really good examples of how amicus involvement has molded the course of law. The canonical example of this is what happened in the 1961 case of Mapp versus Ohio. In 1957, police officers arrived at the home of Miss Dalrymple Mapp in response to a tip that an alleged bomber was hiding in her residence. Mapp called her attorney, who told her not to let them in without a search warrant. So the cops go away, but they show up 3 hours later and forcibly enter her home. She asks them then for a warrant, and they give her something, which at some point they took back. During the search of Miss Mapp's home, the police don't find any evidence of a bomber being harbored. However, the cops did find some pornographic pictures and some comic porn called the Tijuana Bibles that specifically feature Popeye the Sailor Man. At that point, the police arrest Miss Mapp because the material is deemed to be lewd and therefore in violation of Ohio law. At her trial, the search warrant never materializes, but Miss Mapp is found guilty anyway. Mapp petitions the court for review and they grant it. During the briefing stage, both parties focused primarily on the First Amendment issue with regards to Ohio's statute regulating lewd materials. The ACLU, however, submits an amicus brief, which argues for the application of the exclusionary rule, which was created by Weeks versus United States in 1914. The original holding in the Weeks case stated that if evidence is obtained in such a manner that violates a defendant's constitutional rights, such evidence is inadmissible in a criminal prosecution. Until 1961, the exclusionary rule applied only to federal trials because the Fourth Amendment had not yet been incorporated to the states. But the brief submitted by the ACLU argued that the exclusionary rule should apply to state criminal proceedings as well. Using the arguments put forward by the ACLU, the court overruled a previous decision and applied the exclusionary rule to states. Notably, that came from an interest group brief. So this is profoundly important in extending the scope of law, as neither of the direct parties in the case made such an argument. That's a really commonly cited anecdote of how amicus briefs can find their way into majority opinions. It isn't clear what happens systematically, however. To assess how amicus arguments influence court opinions, an innovative approach in political science uses plagiarism software to see to what extent the court plagiarizes or lifts ideas from amicus briefs. Beyond that, however, amicus briefs also provide argumentation for potential separate opinions, and they make it easier to dissent because justices have a thoroughly researched and argued position from which to borrow. So there are inroads being made into understanding how language from these interest group briefs work their way into opinions. But right now, the only thing that I expect you to know is just this additive influence of stacking up the number of briefs filed on behalf of one party versus the number of briefs submitted on behalf of another. So by way of quick summary, today we've learned that interest groups are heavily involved in cases before the United States Supreme Court. Organizations can participate by sponsoring litigation, which means that they quite literally finance the appeals process and provide other resources, or interest groups can participate as amicus curiae at either the agenda setting or the merit stages. We focused primarily on amicus brief submissions because that's the most common tactic pursued by interest groups. When and why groups choose to get involved depends on the membership goals of the group. We also discovered that there are many types of interest groups that can participate, from individuals to businesses to unions to governments. And finally, the most important point is that interest group participation does in fact matter. It influences the voting behavior of the justices on the court, where more amicus briefs decrease the consistency of justice voting behavior. As usual, work your way through the topic objectives, define these things, be able to distinguish between membership and institutional-based groups, figure out what motivates them to get involved, when, why, and then use the additive effect to figure out by how much interest group involvement creates instability in our predictions of justice voting behavior at the merit stage. As always, if you have any questions or comments or anything to say at all, please don't hesitate to use the discussion forum.